A very good evening to one and all. On behalf of our management, our director, Dr. Shashikala Gurpur, faculty members and students, we are indeed very privileged to host Judge Francesca Fiecconi today for the IALS Distinguished Guest Lectures Speaker Series. To start with the program, I will now introduce and I will request our director, Dr. Shashikala Gurpur ma'am, to give a brief introduction about IALS and also welcome our esteemed guest.
Thank you, Professor Sujata Arya and Honorable Justice Francesca, Madam. A very warm welcome to you. At the same time, also, I welcome my colleagues, respected colleagues. I welcome my dear students who are waiting there to listen to Madam. At the outset, I'm very proud and happy to introduce the International Association of Law Schools, which is a very unique body, which has in its fold more than 100 law schools from across the world. We host a Dean's Network as part of this Law School Association. We were very fortunate to introduce a new network into that, a new committee called Judges Committee. And I'm very happy to share with you that Justice Francesca is one of those rare members who believes in contributing to legal education, which prepares the next generation judges and lawyers. IALS has been created long ago in the early part of this millennium by about 2003. However, with the leadership of Attorney Frank, it has assumed, who is also a professor of law, it has assumed new dimensions, whereby he started with the committee members like us, a lot of new initiatives to enhance the quality of legal education across the world. It also meant sharing some of the best practices. As you all know, every legal system has got judicial contribution to legal education. Justice Francesca, when you were in Symbiosis Law School, Pune in 2017 for the Global Law Deans Conference, which some of our students couldn't attend because it was coinciding with their break, had you witnessed the diversity of legal education in our country coming across through the representation of law schools and the presence of the professors. In India, we have right now about 1,500 law schools. When you came, it was about 1,250 law schools. So we have galloped the number of law schools with the growing population of adolescents. You know, India has right now 65% of the demography represented by this age group ranging from 17 to 35. So because of this, the demand for undergraduate education and particularly legal education has increased. In India, legal profession is the only profession mentioned in the Constitution, and lawyers enjoy a place of honor. So also the judges, because our bar contributes to the bench, unlike the European practice where you have career judges. So in India, we also have judges strongly participating in legal education. We have many ways by which judges participate. One is majority of our national law schools, which are universities of law, unidisciplinary universities, we have about 25 of them, have chancellors coming from judiciary. And then the selection process, the syllabus formation, etc., is done by the leadership taken by the judges of the high courts of India in the respective province. Secondly, we have judges after retirement joining our committee at the legal education regulation body called Bar Council of India, where we have Justice A.P. Mishra, one of the senior most members of Indian bench, regularly contributing. I have had the privilege of working with him, working on the curriculum. Thirdly, we also are a little wary of judges' stronger participation because we love to maintain that critical relationship with judiciary as a legal institution. But because of our university's long-term association with judiciary and also our management's own contribution to judiciary, we have had a very strong relationship despite being in the private sector. I must tell you that IALS association for us has been a boon because we already have had 2 eminent judges addressing us in last 1 month. This new program of IALS has helped us to bring Justice Goldstone from South Africa, who was a super hit with students, and then came Justice Hedigan, who shared the European Union experience, European Court of Human Rights experience with the students. And today we have had the privilege of hosting your ladyship, which is which is a moment of pride for all the leadership people here, because our law school is uniquely led by majority women faculty and women leadership figures. So also our university, as you have witnessed way back in 2017, our Vice Chancellor, Pro-Chancellor are women. Now, by way of another additional information, I would like to share that IALS engagement with SLS Pune has resulted in large number of collaborations with lead law schools. We have had law scholars from Africa and other places coming and spending time here, visiting faculties coming here and forming up relationship, bilateral relationship. Our students getting good exposure. For example, our past student union president got selected to Cornell Law School for pursuing his master's. It was motivated and strengthened by one of the Cornell Law School professors who attended the IALS Global Meet. So our law school is a meeting point of such great ideas, people, and giving support to the career progression of our students and helping them to prepare themselves for global careers and cultivating global competencies. So as I welcome you, I'm very humbled by the eminent track that you have had as a member of the Judiciary in Italy, as a justice of the Supreme Court of Italy, and also your love for symbiosis and love for India. I'm also happy to welcome our students to listen to an eminent personality from entirely different jurisdiction, but the jurisdiction with which we have had historical ties. I was just sharing with my international law students a few days ago while teaching the history of international law, and also when we teach comparative law, we say that large portion of common law was developed, being inspired or drawing inspiration from Roman law. And my own trip to Catania University as part of our European project, when we were validating our curriculum, had two practicing lawyers, Italian lawyers, sitting at the table and discussing the curriculum. I felt that there was so much of depth of concepts, jurisprudence, and legal knowledge. And no wonder that common law has drawn its inspiration from Roman law. It is the Roman law which developed the idea of jus gentium, the gentleman's law, or the lex mercentoria, which led to the whole body of mercantile law, law of the sea, the maritime law. So you could see the origins of a lot of these global legal practices coming from the Roman practice, and if not to confine it, but to describe it or qualify it, if I may say, that you feel the remnants of that in the legal minds of Italy. Madam, I'm also happy to tell you that our announcer, who got a little delayed, but who is here, Lasya, she has taken her master's from Turin University. So that will also be a point in this law school, that we have our faculty trained abroad. We get international expertise and experience to the table to inspire. And Lasya has been our alumna, so she must have drawn inspiration from the internationalization agenda, which is aggressively pursued in this law school. So welcome once again. Welcome students, welcome faculty, and let's listen to Madam once Professor Arya and Professor Lasya lets Madam to the podium. Over to you, Professor Lasya.
Thank you so much, Dr. Gurpur. Dr. Shashikala Gurpur has been instrumental in and has made tremendous contributions in the internationalization efforts at Symbiosis International Deemed University, especially for the law schools under the banner of Symbiosis International University. She has led and has been recognized by many international associations, international bodies such as the IALS, under whose aegis we are conducting this lecture series, and also the ASLI, the Asian Law Institute, the IUCN, the GAJE. So in recognition of her contributions, in fact, we She was listed in the book of 100 legal luminaries in India by LexisNexis, and she has also been conferred with the prestigious Kittur Rani Chinnamma Award for her contribution towards empowerment of women. So we are so honored, ma'am, to have this introduction to Justice Francesca Fiecconi by you. So I would like to now introduce to our audience Justice Francesca Fiecconi. She's the judge of the Supreme Court of Italy, born in Ancona, Italy, and she lives in the north region of Lombardy, Milan, Italy. In 1984, ma'am graduated with a 110 cum laude at Pavia University, Faculty of Law. In 1986, after a public national examination, she was appointed for a lifetime as judge of the Italian court in Rome. And from 2017 onwards, she has been promoted as judge of the Italian Supreme Court in Rome. And she's attached to the 3rd Civil and Commercial Chamber, where she works at present. From 2012 to the present, she has also been working as a professor under contract of the Department of Jurisprudence of Università Statale di Milano and the Commercial and European Law. And she also conducts master classes for public examinations. We are so honored to have your presence with us, ma'am. And we can assure you that the audience that you'll be addressing are also very intellectual and would greatly benefit from everything that you have to share with us today. So I would now invite you to address our gathering this evening.
Thank you. Shall I start now? Yes. Okay, thank you very much for leaving me the floor, and I really appreciated such an invitation from you, since I had the opportunity, and I feel lucky for that, of visiting your school and to see how many supplies and how many opportunities you have in such a big and amazing school that stays also in a wonderful place of India. And I have to thank also IALS that gives us this opportunity to share thoughts, because I think, as a professor told us before, that I think that there are a lot of ties between different legal systems, and we have to start to know each other and to share different thoughts in order to discover that the principles of laws are more or less the same values to share. And I will start this very challenging issue, which is about civil procedure during COVID pandemic times, just going through the constitutional principles, because I think that in all the legal systems now we have to consider that the Constitution is the main tool we have in order to govern every kind of problem. When there is a good constitution within a legal system, so we can cope with every kind of problem, also during these tough times. So I will talk about the new constitutionalism, which means that the Constitution is considered not like a chart, a simple chart, but as a tool for power, restraint, and enforcement of rights. And in doing that, I consider that the new constitutionalism has to have 5 pillars. And if we miss one of these pillars, we can say that we don't have a good constitution in one legal system. So when we have to go through a legal system, we have to see the first chart, the Constitution, and to check whether there is a consistency with the 5 pillars that I focus in order to state that there is a real constitutional system in the system. The first pillar is the Constitution felt as a backbone of the legal system. We know that in the past times, normative settings and judicial rulings were left to discretionary and extemporaneous regulation, available to whom was governing a submitted community, either by the obvious force of the facts or, at best, an illuminated vision of power. Nowadays, the constitutional norms stemming from a written constitution or a constitutional tradition, or such in the common law systems, represent a unitary set of fixed rules aimed to define, firstly, the structure and the function of the state apparatus. Secondly, the state power to interfere with the life of citizens and the community in general. In such cases, it comes to the role of the rule of law, as we call it in Europe, and other sources of law to build a legal system complying with principles settled by the Constitution. In other terms, in the construction of one legal system, the constitutional rules constitute a fixed legal entity as opposed to the flow of different sorts of legal rules. That means that the legal rules may change, but the Constitution might not change. Second pillar is the supremacy of the Constitution. A Constitution chart or tradition accompanied by a form of different sorts of legal rules and principles of laws is not sufficient to build a state governed under a constitution. There must be the recognition of the supremacy of the Constitution over the flow of legal rules and judicial statements that constitute the complexity of the legal system. That means that the Constitution, while it justifies its validity, it establishes the primacy of certain rules and values, most values. Historically, the idea of the supremacy of the Constitution over any other sources of law has been first established by the Anglo-American legal system, as we know, namely by the Declaration of Independence of July 4, 1786. Since then, equality among human beings, consent of the governed ones to the governing power, and recognition of the unalienable rights to life, liberty, and pursuit of happiness are the basic components of one constitution also at the present time. The presence of those components is essential for the establishment of the supremacy of the Constitution as opposed to the supremacy of the existing power. This is very important to stress. The presence of those components is essential for the establishment of the supremacy of the Constitution as opposed to the supremacy of the existing power. That means that there is no power that can go beyond the Constitution principles. Third pillar is the constitutional judicial review. The supremacy of the Constitution over the sources of law means also that the law cannot contradict the constitutional text. See Marbury versus Madison, and Supreme Court case, of a very old one of 1804. Therefore, even nowadays, the supremacy of the Constitution is evidenced by the fact that a law contrary to it shall be stated ineffective, and the state powers, at whatever level, are obliged to comply with it by not applying the contrasting law. the presence of an independent constitutional justice capable to assess whether the law complies with it or not, whose name is not only the adjudication of unalienable rights and the definition of the state powers, but also the enforcement of those rights and the curb of the illegitimate exercise of power by central or peripheral organism of a state. The judicial review of laws and norms under constitutional terms, therefore, is the condition for not betraying the role of the Constitution as a tool for powers restrain and enforcement of rights, no matter how it is organized in the legal system. Indeed, even if the way to obtain judicial review of laws may change from state to state, it must serve the same purpose. It requires also a reliable and independent judicial system too, not only a constitutional court, a Supreme Court, but also an entire judicial system which is governed under the rule of law. Fourth pillar, it's the Constitution as an intangible good. Besides the presence of a public and independent authority that works as impartial guardian and mouth of the Constitution, separation of powers must be the normal way to contain excessive power and the desire to overcome the constitutional text. Separation of powers means also that the constitutional text is not the book of dreams to be realized for the advantage of the few ones to whom it is given, but a living text. This is very important, a living text by which every form of power and social organization shall be inspired. Mainly, the Constitution cannot work as a program of the government, since it can live absurdly in the absence of a government, as I told you before. That means that the constitutional text works as a general binding law that cannot be changed, although it may be revised by amendments passed through a rigid protocol and procedures among the different branches of the parliament. For instance, Article 139 of Italian Constitution prohibits, namely, any revision of a republican form. In other terms, as the constitutional text shall not be betrayed by the existing powers, even if not formally overturned, it cannot be reduced as a sleeping beauty or a dead shell, because it is the identity element of the people organized under its basic rules. The fifth pillar nowadays is still more important. It's about the international constitutionalism. Wait, because I don't know if I missed you. Okay. After the end of World War II, the states have strengthened the basic principles of the Constitution by asserting the fundamental human rights in different international binding agreements, such as the Universal Declaration of Human Rights of December 48 and the European Convention on Human Rights of November 1950. You can find all those documents in the internet, and just to see how many articles they provide for. Even the European treaties have taken this new commitment by incorporating the same principles in the Nice Declaration of 2000, finally incorporated in the European treaties in 2009, that represents the higher form of the new European constitutionalism. There is also mention about social rights inside this declaration. Nowadays, it is the common European legal system and judicial space, more than the single European market, that is building up a legal area based on mutual recognition, simply harmonizing national legal systems. The role of its two cores of Luxembourg and Strasbourg and the widespread judicial national review proved as being fundamental in guaranteeing a common feeling of legal security and enforcement of human rights among European member states. Confidence in the European judicial area is not limited to partial responses to specific emergencies, but to statements of principles of law as enshrined by the charters of fundamental rights. This new pattern of international constitutionalism works as a powerful tool to refrain national existing powers by deviating from the common fundamental rights. That means that the member states have to comply with the principles as stated by the two courts. Now we see what's happening during this tough time, during the time where pandemic is overruling every kind of legal system. I think that the pandemic era is teaching us, giving us some lessons. And I want to give you some light on the lessons learned during this short time, but intense time, I will add. Lessons learned and challenges faced by the judiciary during and after the COVID-19 pandemic are very important in order to see how a possible future we have to face. The best approach to analyze the justice system during COVID-19 pandemic is to inquire on how the new international constitutional principles shall work during that time. The COVID-19 pandemic is a health crisis with serious human and social consequences, such as physical distancing, social lockdown, stress on a healthcare compartment, hard restrictions of personal and enterprise freedom, etc. All factors that lead to government supremacy over the legislative power. As a positive effect, it has created challenges even for courts and judicial authorities in the member states. As regards to the justice system, it invites to reflect on the innovative measures that can arise within judicial systems. During these times, the European Commission for the Efficiency of Justice of the Council of Europe, which is called CEPEJ, after a French name, supported the member states in improving the efficiency and quality of their judicial systems in order to ensure that they operate in line with the standards of the Council of Europe and meet the needs of those seeking justice, rights such as the right to a fair trial and protection of individual rights. In such a legal conventional framework, every member state has to be the guardian of efficiency, that means good timing of justice, effectiveness, access and quality of justice, and efficacy, which means quantity of the demand of justice, response to justice. Member states have made considerable efforts to adjust to new circumstances within a short time and to make the best use of existing resources to ensure the functioning of their courts. Therefore, it is also outlined that they should maintain the momentum and draw the lessons from this experience. Mostly, the crisis cannot be used to excuse deficiencies in judicial systems and even less to reduce standards or breach legal guarantees. Such a health crisis may be repeated. We have to think about that. Therefore, the judicial systems have to be prepared, notably when it comes to effective solutions to ensure the continuity of court work and access to justice while respecting individual rights. In this context, the CEPEJ reminds the member states of the following important principles enshrined in an official statement, such as Principle 1, human rights and rule of law. Trust in justice must continue even at a time of crisis. There cannot be a suspension of rights during this time. The principles of Article 5 of the European Convention on Human Rights, right to liberty and security, and Article 6, right to a fair trial, have to be protected at all times and become especially important during the crisis. The continuous functioning of the judiciary and of the services provided by justice professionals needs to be ensured based on European standards. A crisis requires immediate and urgent response, we know. However, any kind of a reaction to the crisis must be strictly based on the principles of the rule of law and must respect and protect human rights. Emergency measures must respect the principles first of legality, legal certainty, and proportionality, and need to be constantly re-evaluated. Judicial authorities, as well as representatives of justice professionals, should, where appropriate, be consulted on the emergency regulation. Any measures introduced must have a fixed end date, and judicial review must be possible in due time. If I have to talk about the Italian legal system, I have to admit that all these kind of rules and principles so far have been complied because all the emergency rules have been taken under consultation, after consultation with the most parties like lawyers, judges, the judiciary, and the government, and administrative staff. So there has been a constant also re-evaluation of the goodness of these rules, new rules submitted, as we will see after a few minutes. So the second principle is access to justice. During a pandemic, locking down courts might be necessary to protect the health and safety of justice professionals and court users. We have done in our system, legal system, for the first month, more or less. And there has been a suspension of the activity unless there was consideration for urgent cases. And so during this time, it should be done in the locking down court should be done in a careful and proportionate manner, as it results in an important limitation of access to justice, which is a fundamental principle of the rule of law. The public service of justice must be maintained as much as possible, including providing access to justice by alternative means such as online services or strengthening access to information through court websites and such as phone calls, email connections, and so on. This is what happened in my legal system. Greater consultation and coordination with all justice professionals, including lawyers, enforcement agents, mediators, and social services, will help to ensure a good level of access to justice. Also, mediation is an alternative dispute resolution that has been improved during this period of time by the lawyers in the civil proceedings. Access to justice must be ensured for all users, but a time of special attention must be devoted to vulnerable groups who are even more at risk of suffering from the situation. Thus, judicial system should give a priority to cases which concern these groups, such as cases of domestic violence, in particular against women and children, involving elderly people or persons with disabilities, or concerning serious economic situation. Vulnerability arising from the crisis should also be taken into not only by the judiciary, but also by the parliament, who has to build up a system in order to protect people and to strengthen the rules. Principle 3 is a safety, to guarantee safety of persons, ensuring the health and safety of all the justice professionals, as well as of the users in courts, must be a priority during and after the health crisis. Safety measures need to be put in place to respect the necessary physical distancing within court premises. All measures need to be prepared in consultation and explained clearly to all concerned, regularly evaluated and adapted to the new circumstances. They may require additional investment in the court infrastructure. Teleworking should be open to justice professionals. They should be provided with the necessary secure IT equipment, which is still a problem because we are using Teams, which is a software which is very secure, but on the other term, it doesn't give the equipment, a good equipment in order to carry out trials live. Particular attention needs to be paid to their well-being during teleworking, and in particular to the fact that these are exceptional working conditions which may require appropriate support. The problem of appropriate support is a real problem in Italy, because although we have a digitalized civil procedure, we didn't have so far a digitalized trial, which means a video conference trial. And we saw that in the courts, also the internet line connection doesn't work well. So if there are so many personal computer connected to the line, there must be problems in order to deal with all ordinary trial work. So they require appropriate support also in terms of the staff, member of staff, administrative is very important. And so far, our experience is that we had to do that by ourselves, and judges had to to demonstrate also to be good, not only professional, but also good technician in a digital environment. Principle 4 is monitoring case law funds. This is very important because don't have to take into account what's given to us as a tool in order to operate in such a way, and allowing for a flexible allocation of resources as close to local realities as possible during and after the instrumental in ensuring the emergency functioning and preventing any aggravation of existing difficulties within judiciary. The well-functioning case management systems and mechanisms of statistical data collection concerning the functioning of the court is especially relevant during a health crisis. Court presidents, judges, and authorities responsible for court management should continue to monitor and manage cases according to their responsibilities, even remotely. This includes a triage of cases and possible prioritization and the redistribution of cases based on objective and fair criteria and ensuring quality justice. This is as it has been done during this second phase of the pandemic year, where there has been a huge work of judges and presidents of courts in providing guidelines in order to give to the parties to a trial all the guidelines on how to purpose and keep on with the different steps of a civil proceeding. Given the number of cases that could not be processed and the adjournment of hearings, human resources and the budgetary support should have courts to put in place a plan to delays. This is something that is a kind of difficult to realize in Italian courts because the courts, the single courts and presidents don't have an autonomous budget in order to provide for that. They depend on the government supplies. And so there might be some problems in order to enforce and to guarantee the flow of the normal and the performance of the because of the lack of supply and funds. Principle 5 is about cyber justice, now in the area of the cyber justice, and the recourse to information technology offers the opportunity for the public service of continue functioning during the health crisis. Ensuring cyber security and the protection of personal data, especially for European countries, as I don't know if you know, a regulation, a very strict regulation about personal data protection. You can also see it, find it on internet. However, its rapid emergence and the excessive use may equally bring negative IT solutions such as online services, remote hearing, and the video conferences, as well as future development of digital justice, must always respect fundamental rights and principles of a fair trial. They require usually much more time in order to one proceeding. So they promote timing and respecting also the time work and schedule. of the court. To reduce risks inherent in the deployment of IT, two safety users should have a clear legal. There is a strong conviction of the European countries that all these programs must be regulated by the government, especially by the Ministry of Justice, because in order to guarantee security and protection of personal data as well, not to give to private enterprises the dealing of these tools. So a special clear legal basis has to be created also. Special attention should be paid to the most vulnerable groups in this respect. The impact of the use of these technologies on justice delivery should therefore be evaluated regularly and remedial measures taken when necessary. For instance, I know that the bar associations, local bar associations, have given some funds to the lawyers in order to buy different other personal computers in order to be able to work in such a way. And principle 6 is training. Training also during this time is very important. Training is fundamental not only in the university, but also for professionals and also for judges. Because it's fundamental for the effective management of a health crisis in the future. Judicial training should adapt to the emerging needs, including the use of IT, but not only, because we have to think about how many contracts will be breached during this time and to think for how to deal with these breaches. New curricula should be developed to support justice professionals during and after a health crisis as well. Also, let's think about the professional responsibility, medical professional responsibility during this time. It will be a problem also to deal with this case. And training institutions should develop the use of e-learning platform, and specific training on teleworking should be provided for justice professionals. Specific training on the new types of cases arising from the COVID-19 pandemic should also be provided for justice professionals. Justice professionals should be consulted by competent institutions, including via online surveys of such specific training needs and so on, which is something that is starting in Europe as well. Then the principle 7 is about the forward-looking justice. COVID-19 pandemic has also been an occasion to introduce emergency innovative practices. A transformation strategies for judiciaries should be developed, capitalize on the benefits of newly implemented solutions. Some aspects of traditional court functionings should be reconsidered, such as the relations with media, level of use of new technologies, increased recourse to alternative dispute resolution, in particular to mediation, as I told you before. Transforming the judiciary for the future should be approached in a positive manner and always with respect for the fundamental rights guaranteed in the European Convention area. It would also be appropriate to maintain the necessary dialogue between all actors in the justice system and to take advantage of the new relations created between judges, prosecutors, court staff, lawyers, enforcement agents, notaries, mediators, and experts at the time of the health crisis. That means that the pandemic era is also an opportunity in order to surpass and to go beyond the natural stress there is usually between judges and prosecutors, and we are all part of the community. We are called to build up a new justice system and to work together. It is very interesting to notice, for example, that in the Italian legal system, at first, especially criminal lawyers were objecting a lot the video conference trial, and now they are asking for more of it because they had the opportunity to try it and to see which kind of benefit they may have in different conditions. Let's say about prisoners who cannot go outside, and we have to protect them for not being exposed to COVID, and so also to expose the lawyers well, the COVID and the exchanging information with prisoners. So now they are little by little, step by step, understanding that these tools, if are used under constitutional principles and in respect with the rule of law and especially due process rule, it can work. And so that may and it can allows us to assert that we don't have to have any bias we are discovering and using those standards. It would be a challenge in order to improve under the rule of law. So we have to draw some. I would say that the pandemic interval is too long for being terms of a general suspension of constitutional right and the right to a fair trial. It has been the first impact, the paralysis impact. But now we have to think in a different way. Access to quality justice must be enhanced with alternative means, supportive administrative staff, and sufficient funds. Funds are really the most important political gesture done by justice operators such as lawyers, judges, and administrative apparatus is to govern and leverage of its initial curve through constitutional principles, as said before. Thank you very much. I hope the line worked, and now it's question and answers.
Thank you very much, ma'am, for your valuable insights. We can now move on to the question and answer session, which will be moderated by Professor Raj Verma. So may I please call on Professor Raj Verma to moderate this session, please.
Yes, ma'am. Thank you so much. Ma'am, the first question that has come, it says that in the wake of the COVID-19 pandemic, there may be larger discretion that is given to judges to better adapt to the court proceedings for these extraordinary situations. Now, it is possible that this discretion, it will reduce the certainty, uniformity, and predictability of law. So the question is, how can we strike a balance between the procedural rights and the need for keeping the civil justice system operational, while also protecting the fundamental principles of legal certainty and the rule of law?
Yes, it's a really main questions during these times, because as I told you before, the courts prepared different guidelines, local guidelines, because the pandemic is different locally, and so the measure must be differently governed. And there must be some approach different procedural rights, but procedural which are given by the judges. One way in order to overcome all these and to balance the positive and negative effects of these is to create these kind of lines together with the different bar associations. That means that there must be a procedure in advance in order to convene about the basis, the legal basis of these internal guidelines. This happens at every level, at the law courts level and up to the Supreme Court level. And after a few months, I would say that this approach had worked, because there were, at first there was a kind of suspicion by the lawyers in order to, because there was for them a lack of certainty, uniformity, and predictability of law, especially procedural law. But after that, after a time of a trial, I would say that now there are not so many problems, and I don't see, at least when I see some comments about how the procedure is working during this time, I don't see so many complaints. Also because the rule of law, the due process clause, has to be now the goal in order to define the different steps of a trials. There are two ways in order to deal with the trials, proceedings, civil proceedings during these times: under script, under presence, and presence is limited when persons, especially weak person, have to be listened, and under video conference. And so far, the video conference is allowed if there is the consent of the lawyers. Otherwise, the judge can provide for scripts proceeding by scripts like briefs, and or by the trial in presence if requested as an emergency. So I think about during this time we have to give more trust in the judiciary, and the rules have to be built up in order to give these three different opportunities in order not to make feel people under, you know, different rules depending on different and uncertain circumstances. The rules have to be clearly given, first of all.
Ma'am, the next question is, what steps can the judiciary take to restrict the executive's widening powers in terms of executive orders during the current pandemic, while also ensuring the proper balanced separation of powers?
Yes, this is the question given by students, or no? Okay, it's about the restrictions on the government powers. It's a problem, a worldwide problem. I think that the main, the best tool in order to solve this is to see our constitution, as I told you before. If our constitution is built up we sure find in the constitution a section about the emergency powers of the government. And now we are seeing that every government is recurring to emergency power. But for instance, in the Italian constitution, there is possibility for having long distance rules, longer lasting rules by the government during emergency time. They have to be approved by the parliament within 2 months. And that means that the government has to follow principles of law, and emergency rules cannot last forever. So there must be always a survey over this, also by the judiciary, because if the judiciary has to apply rules which are not, which are being approved only by the government, especially by the presidents of the government sometimes, and not approved by law in legal terms. So this law can be challenged as unconstitutional, contrary to the Constitution. So the check of the judiciary during this time is very important as well. But also, I think we must check if our Constitution has tools in order to impede all this situation.
Yes, ma'am. Thank you. The next question is that there is an ancient Indian tradition of Nyaya Panchayat, what is community resolution and informal tribunals that are headed by village elders. So, and that has been given legal sanctity. So, in the current times, do you think that in such times, informal and community-based dispute resolution may be the need of the hour to ease the burden of the judiciary?
As I told you before, I think this is a good way in order alternative dispute resolution could be a good way in order to give a good answer of justice, but to guarantee access to justice, especially in times of not only health crisis but also economic crisis. The problem is that these alternative arbitrators must be independent, and there must be also a clear cut of legal rules in order to define in a good way the interests of people. Because the problem is that escape to justice will be also so mediation and alternative tools for resolving and assessing trials and disputes could be a problem when on this side governing there is no possibility also for lawyers to govern the mediation phase. There must be also a possibility to review also the mediation assessment. And in terms of the contract that can be challenged against, or also in terms of having guarantees for independent arbitrators.
Thank you, ma'am. Ma'am, we just have time for one final question. So the student is asking that as we have witnessed mass violations of lockdowns in the present times in major countries like the US, what could be some methods for the strict observance of lockdown by the citizens by way of civil procedure?
Yes, it's the question number, sorry, it's in the countries where the virus is number 6, I think. In the countries where the virus was out of controllable bounds, do you feel that it was due to the unprecedented nature of the pandemic, or was it also partially due to the failure of constitutional mechanism in the state? If so, how? I think it worked in this both ways, because pandemic has unprecedented impact on the systems. But also there has been in some countries a bad reaction to it, because the social distancing has been evaluated as a pressure on people in order to lose the liberty, which is not the case in Italy, but happened in Italy because it happened, but in our system there is much more problematicity in order to preserve elder people. We are an old country. We have a lot of elder people to care and to care about, and the main problem of the government was to convince people to lose their own private liberties in order to save life. That happened, and I think that it has been in a personal adhesion to the call for putting apart for a while all their own and personal liberties and freedom. That is something that didn't work in some states where the concept of liberty, of personal freedom is different. So during this pandemic year, it is a problem, especially for democracies which are conducted under both to govern. The disaster is causing as an in some states, not all the states of the United States, but all this attitude about personal liberties is affecting, especially also the economy of an entire country. So I think that, and to see how to use this kind of good emotions, causing the fact that people have their own personal rights. I'm finished. Are you in? Hello?
Yes, ma'am. Thank you very much. So on behalf of Symbiosis Law School, Pune, I extend my gratitude to Justice Francesca Fiecconi. Thank you, ma'am, for sharing your insights and engaging our audience on such a current topic with such expertise from your own experience. And you also addressed issues of constitutional law and civil law, and we surely hope there will be more opportunities for us to collaborate and glean from your experience in the future. We are very grateful to Dr. Shashikala Gurpur for her excellence and vision for this lecture series and her commitment for quality legal education. Thank you very much, ma'am. We also thank the organizers of this program, Professor Sujata Arya, along with the International Cell, Professor Raj Verma for moderating the discussions, and the IT department for your constant support. And last but not the least, we thank all the participants for your keen questions and for making this lecture fruitful and successful. So thank you very much to one and all.